The Cole County Sheriff just put out a letter telling citizens that a newspaper reporter didn't follow the appropriate legal channels for a sunshine law request. He said no formal Missouri sunshine law request had been submitted. Here's the problem: there is no such thing as a formal sunshine law request. The law doesn't require one. And the sheriff either knows that and is hoping you don't, or he doesn't know the law he's supposed to be following. Either way, that's a problem. And he's not the only one. The Missouri Capitol Police just denied a request for their body camera policy. Their body camera policy under a national security exception. One of the most accomplished sunshine law litigators in Missouri said he'd never seen anything like it. So let's talk about the Missouri Sunshine Law, what it actually says, how you use it, and what happens to public officials who think they get to make up their own rules. I'm Patrick Nolan. I'm a Missouri attorney. This is not legal advice, this is legal information. And today you're getting a crash course in one of the most powerful tools Missouri citizens have. Chapter 610 of the Revised Statutes of Missouri. That's the Sunshine Law. It has been on the books since 1973. And the core principle is simple: government business is the public's business. Meetings, records, votes, actions, deliberations. If a public governmental body is doing it, you have a right to know about it. The statute says it should be liberally construed in favor of openness, and any exception strictly construed. That's not my opinion. That's section 610.011. It covers city councils, county commissions, school boards, sheriff's offices, state agencies, even quasi public bodies that take government money or exercise government authority, including, for those keeping score, the Cole County Sheriff's Office. Now let's talk about how a sunshine request actually works, because apparently there's some confusion. Step one: figure out who has the records. The Sunshine Law doesn't have a central repository. You go to the body that created or holds the record. Step two: put your request in writing. Email, letter, carrier pigeon with a note tied to its leg. The law does not specify a format. And here's the part Sheriff Wheeler should probably read twice. A public governmental body can ask you to fill out a form, but it cannot require it. That's not me talking. That's the Missouri Attorney General's office. So when a sheriff tells a reporter you didn't follow the appropriate legal channels, what he's really saying is, you didn't jump through the hoop I invented. The law doesn't have that hoop. Step three: be specific about what you want. Include dates if you have them. If you want electronic copies, say so. The law says they have to provide records in the format you request, if that format is available. Step four: you do not have to explain why you want the records. No justification required, none. Now, the timeline: the custodian of records has to respond, not necessarily produce, but respond, by the end of the third business day after they receive your request. If they can't produce the records immediately, they have to tell you why and give you the earliest date they'll be available. They can exceed 3 days for reasonable cause, but they cannot just ignore you. If they deny your request, they owe you a written statement citing the specific provision of law that justifies the denial. Not "talk to our legal team," not "you didn't ask right." A statute. Let's go through Sheriff Wheeler's letter, because it is a masterclass in how not to respond to sunshine law scrutiny. He wrote that the News Tribune reporter was provided with clear instructions on how to properly request the policy through the appropriate legal channels. He said the reporter acknowledged attempting to circumvent the established process outlined in the Missouri Sunshine Law. Circumvent the established process. Think about that phrase. The established process under the Sunshine Law is, you ask, they respond. That is the process. There is nothing to circumvent. Then he wrote, no formal Missouri Sunshine Law request has been submitted for our body camera policy. The word formal is doing a lot of heavy lifting in that sentence because the law doesn't use it. The law says each request for access to a public record shall be acted upon as soon as possible. It doesn't say each formal request. It doesn't say each request submitted through the county's preferred portal. It says each request. If a reporter contacts your office and asks for a copy of your body camera policy, that is a sunshine request. Full stop. You don't get to pretend it isn't because he didn't use your magic words. And then, my personal favorite, the sheriff wrote, this raises a broader concern about the line between responsible journalism and sensationalism. Sheriff, when a journalist asks for your public records and you tell him he's doing journalism wrong, that's not the defense you think it is. That's the story. Now, the Capitol Police took a different approach. They didn't claim the request was filed wrong, they just said no. A Wardsville resident named John Stambaugh and the News Tribune both requested the Capitol Police body worn camera policy. Both were denied under Section 610.021, subsection 19, paragraph D. The exception for records whose disclosure would impair the public governmental body's ability to protect the security or safety of persons or real property. That exception exists for a reason. Emergency response plans, security system details, tactical protocols, things that, if released, would genuinely help someone do harm. A body camera policy is not that. A body camera policy tells officers when to push the record button. Attorney Dave Rowland, one of Missouri's most experienced sunshine law litigators, said he had never seen an outright denial like it. And here's what makes it worse. Section 610.024 says that if a record contains both exempt and non exempt material, the government body has to separate them and release the non exempt parts. You don't get to deny the whole document because one section might qualify for an exception. The Jefferson City Police Department, which got the same request, turned their body camera policy over in 7 hours. The Missouri State Highway Patrol publishes theirs online. The Columbia Police Department publishes theirs online. So either the Capitol Police have body camera procedures so sensitive they would compromise state security, or they just don't want you to see them. You can decide which is more likely. Section 610.021 lists the legitimate exceptions: litigation and attorney client communications, real estate negotiations, personnel matters, hiring, firing, discipline, but not names, positions, salaries, and length of service. Those are always public, always. Records protected by other statutes, scientific innovations with proprietary interests, security systems, and structural plans. The key word in every one of these: authorized. The body is authorized to close these records, not required. Even when an exception applies, the default is open. A public body has to affirmatively decide to close a record, and it has to be able to justify that decision. So, what happens when they get it wrong? Section 610.027. Any aggrieved person, any Missouri taxpayer or citizen, the attorney general, or a prosecuting attorney can bring an enforcement action in circuit court. Here's the part that should get every public official's attention. Once you show that the body is subject to the Sunshine Law and held something closed, the burden shifts to them. They have to prove they complied. You don't have to prove they didn't. Two tiers of penalties. A knowing violation carries a civil penalty of up to $1,000. The court may order costs and attorney's fees to the person who brought the case. A purposeful violation, meaning you consciously intended to violate the law, carries up to $5,000. And for purposeful violations, the court shall order attorney's fees. That's mandatory, not discretionary. Mandatory. The court can also void any action taken in violation of the Sunshine Law if the public interest requires it. You have 1 year from when the violation becomes ascertainable to file, with a hard cap of 2 years. Quick update on recent changes. House Bill 145, passed last session, lets public bodies require payment of fees before fulfilling a request. If you don't pay within 90 days or 150 days if fees exceed $1,000, your request is considered withdrawn. New closed record exceptions were added for individually identifiable information about minors held by cities and park boards, camping reservation data for parks, and the locations of endangered species. The Sunshine Law exists because Missouri decided that transparency is the default, not something a sheriff grants you when he feels like it, not something the Capitol Police get to override because accountability makes them uncomfortable. If you make a request and get stonewalled, you have two options: file a complaint with the Attorney General's office, or go to circuit court, where the government has to justify its secrecy, not the other way around. And if you're a public official watching this, sheriff, police chief, school board member, whoever, here's free advice from an attorney. Respond within 3 business days every time. Even if the response is, we need more time, don't invent procedural hurdles that don't exist in the statute. And if you're genuinely unsure whether a record should be open or closed, Section 610.027.6 lets you ask the AG for guidance. That's the smart play. Writing a letter accusing a journalist of sensationalism because he asked for your public records, that's not the smart play. I'm Patrick Nolan. That's the law.